Come to order, all right.
All right, good morning. Please be seated. All right, we're here for the state of Florida versus Thomas Stein, who is present. Case number 24-CF-272. If everybody will make their announcements, please.
Good morning, Your Honor. Sarah Miller on behalf of the state. Good morning, Melissa Wolf on behalf of the state.
David Wheeler and Julian McCoy on behalf of Mr. Stein.
Good morning. All right. Ready to proceed?
If we may just have 5 minutes, our families are all getting to the courthouse now, and I'd like to.
They're in the line down there?
I believe so, Your Honor.
Okay. All right, so we'll be in recess for about 5 minutes. Will you let the clerk know to let me know when everybody's here? All right, so we'll be in recess for about 5 minutes.
Come to order, all right.
All right. Good morning. Please be seated.
Good morning.
All right, everybody will make their announcements. Again, we're here for the state of Florida versus Thomas Stein, case number 24-CF-272.
Sarah Miller on behalf of the state. Thank you, Your Honor, for that additional time. Melissa Wolf on behalf of the state.
David Wheeler and Julian McCoy on behalf of Mr. Stein.
All right, Mr. Stein is present. We're here for sentencing. Is the state prepared?
The state's prepared, Your Honor.
And is the defense prepared? All right, let's go ahead.
Before we get started with some of the victim impact testimony the state would like to offer to the court, I just thought it might be important or a good idea to talk about sort of the parameters of sentencing, because it's a unique situation or a less common situation when it's a juvenile direct file who's been convicted of a first-degree felony that's a capital offense. So just as a preliminary matter, since he was convicted under Florida Statute 782.04 subsection 1, that does make it a capital felony, subject to sentencing under 775.082 subsection 1B2. And I point that out because that does apply to defendants who are under the age of 18 at the time of the commission of the offense, of a capital offense, and for an individual who was not found to have actually killed, intended to kill, or attempted to kill the victim in the case. That finding made by the jury is important because under 775.0821B2, it does allow the court to sentence the defendant to life in prison or to a term of years equivalent to life in prison if it finds after the sentencing hearing that life in prison is an appropriate sentence. In addition to that, it does require the court to make findings if the court sentences to the defendant anything greater than 15 years. You have to make findings and issue an order that the defendant's sentence is requires a review at the 15-year mark. So at any point, if the court is going to sentence to the defendant to greater than 15 years, the court will have to make an order that he's entitled to that review. The hearing that we're going to have on sentencing is the standard things that you would otherwise be considering, but the court has to consider the circumstances of the offense and the surrounding circumstances, and all of that's outlined in statute 921.1401, and that outlines the hearing when the court's going to make a determination of whether life in prison is appropriate. And then in addition to that, I think it's important the state's prepared a score sheet, and can I offer that to you before we get started?
Yeah, you've shown it to the defense.
This includes only the 3 attempted robbery with a firearm offenses. 775.082 specifically says that score sheets do not apply to capital offenses. So while the score sheet that the court's considering only has the 3 attempted robberies, obviously the court still has to impose a sentence on the capital felony that we're here for. I can offer to the court that the score sheet the defendant was facing before he was indicted by the grand jury on the capital offense, he was originally facing a second-degree murder charge. That score sheet had a total number of score points of 467 points, making the lowest permissible prison sentence he was facing before the grand jury indicted him at just over 27 years. So I think that's instructive for the court, since normally on a capital offense there's not an option. It's either the death penalty or a life sentence. Because he's a juvenile, the court does have to exercise discretion about what the sentence is, and I hope that that's instructive and helpful for the court to know.
Thank you.
I do have some costs that the state intends to ask, the cost of prosecution greater than the standard amount. The state's going to be asking for $2,565.05. I can repeat that for Your Honor if you'd like.
Can you give it printed out?
I do. Can I hand that to you?
Any shown it to the defense?
Yes, Judge, she has. I've spoken with my client. We're willing to stipulate.
Okay.
So I had marked that as state's exhibit for sentencing 1. We appreciate the stipulation
All right.
from counsel
Thank
and the
you.
defendant. So we're asking for those costs in addition to the standard fines, fees, and statutorily required monetary amounts. And then I'm prepared to offer our victim impact if the court's ready to receive that.
All right.
First, we'll call Lillian. Lillian is a family friend of Kayla Rincon Miller, who was the victim of the murder in the case.
Raise your right hand. Do you swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth? You can take a stand. You can proceed whenever you're ready.
Thank you. Would you please state your name?
Lillian Hubbard,
And how do you spell your first name?
Lilliam,
How do you spell your last name?
Hubbard.
And do you know Kayla Rincon Miller?
Yes,
How do you know her?
my friend.
Have you prepared a statement today, or are you prepared to read something to the court regarding victim impact in this
Yes.
case? Would you go ahead and do that? And I'll just have you make sure you speak clearly enough for the microphone.
Okay. Your Honor, my name is Lilliam, and today I stand before you on behalf of the entire Rincon Miller family. We are here because our beloved Kayla was taken from us. While this courtroom knows her as the victim in this case, to us she was so much more. She was a daughter who filled our home with laughter, and a loving sister, a cherished granddaughter, a niece, a cousin, and a dear friend. Kayla was a kind of person who left a lasting impression on everyone she met. She had a heart full of compassion and a smile that could brighten even the darkest day. She had a special gift for making people feel seen, included, and valued. Whether she was spending time with family, laughing with friends, or encouraging someone who was having a difficult day, Kayla gave of herself freely. She was full of life, ambitious, and excited about her future. She had dreams of graduating, building a career, traveling, and one day creating a family of her own. She loved making people laugh, taking pictures, listening to music, and creating memories with those she loved. She brought joy wherever she went, and her presence made every gathering feel complete. Most of all, Kayla loved deeply. She loved her family fiercely and shared a special bond with her sister, who not only lost a sibling, but also her closest friend. She was a granddaughter who brought pride and happiness to her grandparents, a daughter whose love filled our home, and a friend who was loyal, caring, and always willing to be there for others. When Kayla's life was taken, the world didn't just lose another young person. It lost a bright light with limitless potential, a beautiful soul whose life was only beginning. On the day Kayla's life was taken, a part of each one of us was taken as well. No parent should ever have to bury their child. No sister should ever have to grow up without her best friend. No grandparent should ever have to endure the pain of losing a grandchild. Our entire family has been forced to live with a grief that words cannot fully describe. Every birthday is incomplete. Every holiday has an empty chair. Every family celebration is overshadowed by the painful reminder that someone we love should be there. We often find ourselves wondering what Kayla would be doing today, what career she would have chosen, whether she would have fallen in love, gotten married, or had children of her own. Those dreams were stolen from her and from all of us. The emotional impact has been overwhelming. Grief has changed the way we live. There are moments of deep sadness and emptiness that never truly goes away. There are days when simply getting through the day takes more strength than anyone can imagine. Kayla's sister had to learn how to navigate life without the person she loved so deeply. She has missed sharing birthdays, milestones, conversations, and memories that sisters are supposed to make together. That loss is something she will carry for the rest of her life. Kayla's grandparents continue to grieve the unimaginable loss of their granddaughter. The pain of watching your grandchild's life and before your own is something no grandparent should ever have to experience. Our extended family has also been deeply affected. We have all lost someone irreplaceable. As a family, we have chosen to honor Kayla's memory instead of allowing tragedy to define us. We created Kayla's house so that her life would continue to make a difference by bringing awareness to gun violence, supporting families, and encouraging young people to choose hope over violence. While we are grateful that her legacy is helping others, nothing can replace the precious life that was taken. Every act of service we do is born from our love for Kayla and our hope that another family might be spared this unimaginable pain. We want the court to understand that the impact of this crime did not end on the day it happened. It continues every morning when we wake up without her, every family gathering where her absence is deeply felt, and every milestone she should have celebrated but never will. Justice cannot restore what has been taken from us. It cannot bring back Kayla's laughter, her hugs, or the future she deserved. But we respectfully ask this court to recognize the immeasurable value of her life and the permanent impact her loss had on our family. For the court, justice may have been served today, but for our family, there will never be true justice because no sentence can bring Kayla back. No decision can restore the years that were stolen from her or the memories we will never have. What remains for us are the questions that will never be answered, the silence where her voice should be, and a lifetime of learning to live with an absence that can never be filled. Kayla's life mattered. She was loved beyond measure. She is deeply missed every single day, and she will never be forgotten. Thank you for allowing our family to be heard, Your Honor.
Anything from the defense?
In terms of cross-examination?
Thank you.
The state would call Emma Wright.
Raise your right hand. You swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth? Yes. All right, put your hand on. Let's see.
Good morning.
Good morning.
Would you please state your full name?
Emma Wright.
And you're speaking a little low this morning, so I want to make sure that the microphone picks up your voice, okay?
Sorry.
How do you spell your first name?
EMMA.
And how do you spell your last name?
WRIGHT.
And you were a victim in this case of the attempted
Yes,
robbery.
ma'am.
Did you prepare a statement or something you'd like to tell the court about the impact the crime has had on you?
Yes, ma'am.
Would you like to read that now?
Yes, ma'am. On March 17, 2024, there were 3 girls who had just finished watching a movie and wanted some food. During that walk, one of us got shot. There were 3 shots that went off, and there were 3 of us. That night...
I apologize for interrupting you. If you could pull the microphone a little bit further over, it'd be easier. There you go. Thank you.
There were 3 shots that went off that night, and there were 3 of us. That night will affect everyone who ever knew Kayla and who was ever close to her. I'm up here to speak for the people who can't. I'm a victim of a horrible crime, and I have been bullied and discouraged at all. People tried to blame me and my friend Deja for this act of violence. I am here to express the emotional trauma and the distress that this has caused us. I no longer find peace in walking home late at night or engaging in late-night activities. I constantly am on edge thinking something is going to happen. People like to say, your trauma makes you stronger, but me and my best friend Deja have gone through enough in our lives, and what happened that night left us distraught and scared for the rest of our lives. I watched that trauma destroy my best friend. She was so devastated that a childhood friend had passed away. This trauma had given us nightmares, stole our voices, and gave us destructive coping mechanisms. We felt unheard and were bullied for this crime. It is easy to blame the victim than to acknowledge their perpetrators. You don't get to judge or bully the victims of a tragedy that has happened in the span of 1 second. That is all it took for those shots to go off and take the life of Kayla. I am a victim, and I will forever grieve of the loss of Kayla Rincon Miller, and she will forever be in our hearts and will forever be 15.
may stand. Thank you.
Next, the state would call Claire Etienne.
Raise your right hand. You swear affirm testimony you give will be the truth, whole truth, nothing but the truth?
I do.
And thanks.
May I inquire?
You may proceed.
Good morning.
Good morning.
Would you please state your full name?
Marie Claire Etienne.
Can I just move the microphone up a little? Maybe something that might help.
Got it?
Would you please spell your first name?
Marie
And your last name, please.
Etienne.
And you're here to provide victim impact to the court, is that correct?
Yes,
Have you prepared a statement, or is there something you'd just like to say?
I did.
Okay, let's have you do that.
Your Honor, my name is Claire Etienne, and I am the mother of one of the victims in this case. I respectfully submit this statement to describe the profound and the lasting impact that had on my daughter, on me, and my entire family. The day of the attack changed our life forever. My daughter, Luann, was held at gunpoint and suffered severe trauma that required her to be hospitalized and ongoing mental health treatment. As a mother, watching my child endure such fear, pain, was one of the most devastating experiences of my life. No parent should ever witness their child suffer in this way. The trauma was made even more unbearable because Luann's friend, Kayla Rincon Miller, was killed during the attack. In a single moment, my daughter became both a survivor of a violence crime and a young person grieving the loss of her friend. This is a burden that no child should ever have to carry. The effect of this crime did not end at the attack, when the attack was over. Because the trauma she experienced, she was removed from her high school and placed into a smaller school for an entire year. She lost the opportunity to experience a normal school environment with her classmate and friend. Her education, her routine, and her sense of security was all disrupted. The impact on our family have been overwhelmed. Our life became centered around doctor's appointment, counseling, and helping Luann heal emotionally. Every day brought a new challenge as we worked to support her recovery while we are trying to rebuild some sense of normalcy. The emotional toll on me became severe. I was hospitalized twice, overwhelmed with stress, trauma by this horrific event. The fear of almost losing my daughter, combined with witnessing her pain and grief, affected every part of my life. It changed me as a mother, as a person, and as a foundation of our family. This case is not just about what happened on one tragic day. The effect continued to be felt every single day. Luann continued to live with trauma of the attack and heartbreaking of the loss of her friend Kayla. Our family continues to carry emotional scar
that cannot be seen but are deeply felt. I also want to acknowledge Kayla's family. They suffered the loss of their daughter, who was taken far too soon. My heart continued to ache for them, and I pray they find strength and peace as they continue their journey of grief. I respectfully ask the court to consider the full extent of harm caused by this action, not only the physical danger, but also the lasting trauma, the disruption of my daughter's education, the grief, the fear, and the permanent impact on my family. Despite everything she had endured, Luann has shown incredible courage, resilient, and she is determined. I am deeply proud of the young woman that she has become. Although this tragedy will always be part of our life, it will not define her future. We will continue to move forward, honoring Kayla's memories while supporting Luann as she continues to heal. Special thanks to the Cape Coral Police Department and detective and the state attorney teams who have stood by our side throughout this journey. Thank you, Your Honor, for allowing me the opportunity to share the lasting impact this tragedy have had on our family.
Thank you. All right, you can sit down. Thank you.
And the state calls Luann Deja.
If you raise your right hand, you swear a firm testimony you give will be the truth, the whole truth, nothing but the truth. All right, you take a stand. Proceed when you're ready.
Thank you. Good morning. Ma'am, would you please state your name for the record?
My name is Luann Deja,
How do you spell your first name
Louann,
and your last name?
Dejaie.
I know you've been up here a few times. I'm just going to remind you to make sure that the microphone's going to pick you up, okay?
Okay.
Have you come today to present some impact statement about how the crimes have affected you?
Yes.
Would you like to do that now?
Yes.
Thank you.
Good morning, Your Honor. I stand before you today not because I want to, but on behalf of my friend, Kayla Rincon Miller. This is something I never imagined I would have to do. There are no words that can truly describe the void I wake up with every single day. It feels like I'm trapped in a coma that I can't wake up from. Like I'm suffocating, but somehow still expected to keep on living. Losing Kayla changed every part of my life. It changed my relationships with my family, my friends, and the person I used to be. I live with grief, depression, anxiety, and PTSD. The rumors and bullying also played a part in my mental health, and I did not have support from anyone except my state attorneys and my family and my team. Every part of what happened has left a scar on me, from the moment I was held at gunpoint to finding out it was kids our own age, to having to sit in this courtroom and face them. In one split second, the entire trajectory of my life changed, and I will never get that life back. We will never be those girls again. We'll never go to the movies together. We'll never laugh about boys and how stupid they are. We'll never make more memories together. Time was stolen from her and everyone who loved her. I've never lost someone this close to me. It's made me realize how precious time really is, because tomorrow is never promised. Our families will never be the same. I ask myself every single day, what made them do it? My heart keeps trying to understand. The empath in me keeps searching for a reason, because I don't want to believe that people our age were capable of doing something like this, but no answer will ever be enough. There's no winning in this case. No family wins, no lawyer wins, no court wins. The only true loss is my sweet girl, Kayla. I don't stand here today because I care about a sentence. I care about my friend who was taken from me. I ask this court to do what is necessary. I also know that no sentence will make me happy. No sentence will bring me peace. It will not ease my soul, because the one thing I want can never be given back. This is not the end for me. Years from now, I may still have to come back to the courtroom because of this case. While others may move on, I will continue carrying March 17th with me every day of my life. This tragedy doesn't end when this hearing is over. It stays with me when I wake up, when I try to sleep, and every milestone Kayla should have been able to experience with me. Every morning I wake up knowing I still don't have the full truth. I pray every day that God reveals it. I pray that whatever in those boys' hearts that night, whatever led them to make those choices, is brought to the light. I pray that they come to understand the weight of what they took. And I pray that God changes their heart, because hatred and violence have already taken enough. There is no peace for me in this courtroom. I am spiritually changed in a way I don't know how to explain. A part of me died with Kayla that night, and I don't know if I'll ever get that part back. Your Honor, I ask you to please hear my cries. Please do what justice requires, not because it will heal me, but because Kayla's life mattered. She deserved to graduate. She deserved to chase her dreams and fall in love and have a family and grow old. She deserved the future that was taken from her. I miss my best friend every single day. Thank you.
May I have just a moment, Your Honor?
Yes.
Is there anyone else in the courtroom who hadn't arranged in advance to speak that would like to make a statement? Your Honor, the state has no further victim impact to present. I have discussion regarding the PSI that the court ordered and was prepared, as well as the PDR that was ordered and prepared, as well as argument. I don't know if you'd like to hear that now, or I'm not sure. I apologize how
That's
the court
okay.
would like to structure
That's
it.
okay. And I want to make sure both parties did receive both the pre-sentence investigation report and the predisposition report.
We did, Judge.
Okay. Did you have anything you want to present now?
We do have witness testimony, Judge, if the court would like to hear it now.
Okay.
Just wait just a moment. Judge, defense complaint to Paul Patrick Clark.
Raise your right hand. You swear affirm testimony you give will be the truth, whole truth, nothing but the truth?
Yes, sir.
You can take the stand. Proceed when you're ready, Mr. Wheeler.
Good morning, Your Honor.
One second, let him answer.
Mr. Clark, have you prepared a statement that you'd like to read to the court?
Yes, sir.
And if you could just tell us your full name for the record and spell your last name.
My name is Patrick Anthony Clark, and my last name is spelled C-L-A-R-K.
Okay. Go
Mr.
ahead.
Clark, how old are you?
I'm 18 years old.
You have a statement you'd like to read?
Yes, sir.
Go ahead.
Thomas is a best friend. I've known him since the first grade, and we grew up together ever since. Being found guilty of a murder is an extremely serious matter, and accountability is necessary.
I'm sorry, and can you bend that microphone back down kind of to where you're speaking so we can pick up what you're saying?
Yes, sir. No parent deserves to see their child leave before them, and no friend deserves to see their friend leave this earth right in front of them. My deepest condolences go out to the family and friends of Kayla Rincon Miller. While without knowing Thomas's character, it is easy to form assumptions of who he is as a person. My whole life I have known him, and I know he is not just some criminal. He isn't a perfect character, and he has not always made the best decisions in life. However, he doesn't fit the description of someone who is incapable of doing no good in the world. He's always maintained a respectful and mannerly attitude, always ensured by his parents, showing genuine kindness and consistent effort to ensure the safety of those around him. Growing up, Thomas's parents always reminded us about the importance of safety towards others and ourselves. Thomas has never been someone who would take it upon himself to hurt others. I acknowledge that being found guilty for this crime, time is necessary and important for Thomas's personal growth. And this will allow him to demonstrate that he is capable of meaningful self-improvement like he has made these past 2 years. Thank you for acknowledging this letter and your service to the court, Your Honor. And once again, I would like to give my deepest condolences to the family of Kayla Rincon Miller and her friends. And nobody deserves to lose a friend or a child right in front of them.
Nothing further.
Thank you.
Judge, my next witness is Jessica Stein. She just has some more here from Thomas Stein.
You raise your right hand. You swear and affirm testimony you give will be the truth, whole truth, nothing but the truth. Yes. Take a seat.
My question.
Yes, you may proceed.
Good morning, Ms. Stein. Can you spell your name for the record, please?
Good morning. It's Jessicastien.
And how are you related to Thomas Stein?
I'm his mother.
You gathered some letters from some family members, is that correct?
Yes, sir.
Before we begin, who have you gathered letters from?
I've written one myself. There's one from his grandmother, his aunt, his brother, and his great-grandma.
Let's begin with his grandparents. Would you like to read those to the court?
The grandparents.
These are his paternal grandparents?
Yes. Great-grandparents or grandma first? I'm going to read my mother's letter first. Dear Honorable Judge Thompson, I'm Thomas Stein's grandmother, and I appreciate the opportunity to share my heart with the court before his sentencing. I've known Thomas his entire life and have been very close to him as he grew up. I've watched him from the day he was born into the young man he is today. Because of that, I know the person he truly is. Thomas has always had a creative, entrepreneurial spirit. Even as a little boy, he was consistently thinking of ideas and dreaming about his future. One of my favorite memories is that it still makes me smile today. When most children ask for toys and electronics for their birthdays, Thomas made a birthday wish list that included a perfect banana, a watermelon, a pig, and a shovel. His dream was to grow things, have a farm, and build something of his own. That was the kind of child he was. He was happy, imaginative, hardworking, and excited about his life. He also loved being a big brother. He took that role very seriously, and he always wanted to protect his younger siblings. He enjoyed making them laugh, helping them, being someone they looked up to. Those are memories I choose to hold on to when I think of my grandson. There's no question that what happened on March 17, 2024 was a terrible tragedy. My heart aches so much for Kayla's family and everyone whose lives were affected that night. There's nothing in this letter meant to minimize their loss or their pain they continue to endure. Thomas has accepted that he made a terrible mistake by being there that night. He understands his choices had devastating consequences, and he accepts responsibility for the role he played. I believe truly, however, he never expected or intended anybody's life to be taken. He was with people that were not his normal crowd, and one terrible decision changed countless lives forever, including his own family, his own life, and his own family. While Thomas must be held accountable for his actions, I respectfully ask the court to remember he is more than the worst decision he ever made. He was only 16 years old. He is not beyond hope. He is not beyond redemption. And I ask you, Your Honor, to please have mercy during your sentencing and leave Thomas with an opportunity one day return to society as a changed, productive young man. I believe he still has the capacity to learn, to grow, and to become someone who can make the difference in this world. Thank you for the time to read my letter and considering my perspective as someone who loved Thomas his entire life. Respectfully, Thomas's grandmother.
And Ms. Stein, what's your mother's name for the record?
Becky.
Becky.
Yeah.
Full name?
Son.
Last
Becky's
name?
son.
Can you spell the last name for the record?
Sutton.
Do you need a moment now?
Okay.
Would you like to start with his great-grandparents?
Yeah. Okay. This letter is from his great-grandparents, Nancy and John Burkiani.
Can you spell the last name for the record?
Yes, it's Burchianti. We are writing this letter on behalf of our great-grandson, Thomas Roy Stein. Thomas has been a remarkable young man for most of his life. We have had the privilege of helping care for him while he was growing up, and during that time, he often attended Catholic church with us. We watched him grow into a kind, respectful, caring young boy who was always willing to help others. Whenever we needed assistance with anything around our house, Thomas never hesitated to lend us a hand. Throughout his school years, Thomas was an excellent student, earning mostly A's and taking pride in his work academically. We always knew him to be responsible, polite, and full of promise. The loss of his father had a profound impact on him. From our perspective, that tragedy marked a turning point in his life. He began spending the time with the wrong crowd and the wrong group of friends, and made decisions that were completely out of his character for the young man we always known. While that is no excuse for the choices that brought him before this court, we believe those mistakes do not define the young man we have known and loved our whole life. We sincerely believe Thomas has the ability to become the same compassionate, hardworking Christian young man he once was. If he was given the opportunity. We believe he has the capacity to learn from these mistakes, grow from them, and become a productive member of society. We want the court to know that Thomas is not alone. We remain committed to supporting him, encouraging him, and helping guide him however we can. We respectfully ask the court to consider mercy when determining Thomas's sentence. We pray that you consider not only the events that happened that night that brought Thomas before you, but also the life he lived before this tragedy and the potential he still has. On a personal note, I wanted to share with you, Judge Thompson, that your late father had the honor of marrying us back in 1979, and we've always remembered that. Yeah, okay.
That's okay, and he's still alive.
Okay. We just only wanted to share this as a reflection of our respect we have for you and your family and the court. Thank you for taking the time to read our letter and your thoughtful consideration. Respectfully, Mr. and Mrs. John Berchiani.
Thank you.
Jessica, before we proceed any further, you've given me some photos to share with the court. Is that correct?
Yes, sir.
I'd like to play them now. If you just kind of come in here.
Okay.
Where did Thomas go to school, man?
He went to school at J. Cullen English Elementary in North Fort Myers.
This is him at age 6?
Yes, sir.
Who's that with him?
That's his brother Timothy and his brother Taylor.
You have a letter prepared from Timothy?
Yes, I do.
That's Thomas at age 7?
Yes, sir. They both got A honor roll that year in the principal's year award and perfect attendance.
Who is this with Thomas and Angie?
That's his brother in the green shirt, Timothy. He's holding his sister Rosemary and Taylor and Tucker on the other.
Are his siblings here today in court?
Yes, sir.
At age 9? Was Thomas involved in sports?
Yes, he played for Faith Sports.
Basketball?
Yes, sir. Basketball. I believe he played 2 years there with his brother Timothy and his best friend Patrick.
And the family liked to spend time outdoors, is that correct?
Yes, we did.
At age 11?
That's a photo of him. We went to the Naples Zoo. And another photo of him for Student of the Week. I got to go have lunch with him at school, and he got the Principal's Award and perfect attendance and A honor roll.
This is about 5 years before his arrest. I just want to make that clear.
Yes, sir.
Age 12?
I think that's the first day of 6th or 7th grade, in the middle. The one on the left is me and his aunt Jennifer and his cousins and all of his siblings at the shell factory.
Were you and your sister close?
Yes, very.
And consequently, both Thomas and his cousin were also close?
Yes.
And on the right are those his grandparents?
That's his great-grandparents, Nancy and John. After church, we often go to the P.F. Chang's restaurant for lunch.
At age 13?
That was the first time you got to see snow. We went to the Great Smoky Mountains in Tennessee. And the other one there, we went on a dolphin cruise there.
Age 14?
once Thomas and Rosie at the fair. She always wanted to do everything with him. The other one's at Sunsplash, the two, and the bottom is 8th grade graduation with his best friends, Patrick, Alex, and Corey.
And the photo in the upper right-hand corner, a house full of children.
That was my everyday, every weekend. The house was full of kids, Thomas and his best friends.
At age 15?
Thomas holding his baby brother and his big brother on his side, and Tucker. There's one of us at the Maple Zoo on Halloween, and the other one, he's taking Rosie on a wagon ride at the pumpkin patch. That's Easter at my grandparents' farm. We do every single year.
And that's his sister Rosie?
That's his sister Rosie, and she was upset she didn't get the golden egg, and Thomas just gave her the prize out of it, money, just to make her smile.
And on the right, that's also Rosie with Thomas.
Yes, they're at the playground right down the road.
The picture on the right, that's Thomas giving his driver's permit?
Yes, that's him getting his permit. He was really happy that day. We're at the shell factory, and the middle is his sister's baptism, and playing at the park again with his sister.
What high school did Thomas go to?
Mariner High School.
And what grade was he in when he sat there?
10th grade.
At age 16, this is the age Thomas was when he was arrested, is that correct?
Yes, sir. We're at the beach. He loved going to the beach with his brothers and sisters. In the middle, we're at the Mellow Mushroom in Tennessee with the whole family. And that's him with his brother Timothy on top of the mountain in Anakeesta.
On the left is Thanksgiving?
Thanksgiving, yes.
And the photo in the middle?
That's his sibling's birthday, the twins, and Mateo. And Christmas at the Edison Estates downtown.
You have a letter from Timothy you'd like to read to the court?
I do. I'm reading this letter on behalf of my son, Timothy Stein, Thomas's older brother. Dear Judge Thompson, my name is Timothy Stein. I'm Thomas's older brother. I'm 19 years old and I live in Port Charlotte, Florida. I'm writing this because I know my brother better than anyone, and I'm asking you to consider who he really is when you decide his sentence. Before I talk about Thomas, I want to say something first. I know that a 15-year-old girl named Kayla Rincon Miller lost her life, and that her family is living with grief that is insurmountable. My intention is not to overshadow that, and I'm truly sorry for her friends and families who were dealing with this unbearable loss. Thomas was 16 years old when this happened. I'm not stating that as an excuse, I'm stating it as a fact. I'm saying because it's the truth. We grew up together. And with that, I went through life side by side. The brother I know is nothing like the person described in the courtroom. Thomas and I were dead set on our goals in life. We would go to the gym, we were eating healthy, we would hang out together. His face was always there during family gatherings. His presence was uplifting. He was a good person in his soul. No one could doubt that around him. These events leading up to March 2024 wasn't really who Thomas was. It was who he was around. At 16, he was surrounded by the wrong group of people. And similar to many teenagers, they become their peers. The purpose of this is not to shift the blame off of him. However, I watched this happen in real time, and I truly believe he never intended for anything like this to ever happen. Since his arrest, I have firsthand watched Thomas try to become the best person he can with what is available to him. You can always find him exercising, or reading his books, or demonstrating that discipline we built together growing up. He has taken a lot of educational courses available to him on his tablets, trying to learn as much as he can. Nobody is making him do any of this. He knows the only thing that can control right now is who he becomes and who he's choosing to grow into every single day. I want it to be known that Thomas will never be alone. Our family is committed to him for the rest of his life. I will visit him. I will support him however I can. I will be there for every program and every step of rehabilitation available to him. If he is ever given the chance to come home, he will come home to a family that is ready to help him build an honest life. He asked for my guidance to make a positive difference in society. My request is not to ignore the gravity of this situation. I just want to show who Thomas really was and how he is. He was 16 years old, who got pulled in by one of the worst influences around him, and who still has it in him to become the man our family knows he can be. I respectfully ask for a sentence that holds Thomas accountable, but leaves him the possibility of hope and future opportunities. Thank you for taking the time to read this. Respectfully, Timothy Stein, the brother of Thomas Stein.
I actually have a letter from your sister,
Yes.
Jennifer.
I have a letter from his aunt, Jennifer Stein, to the Honorable Judge Thompson. My name is Jennifer Stein, and I am Thomas Stein's aunt, and I'm writing respectfully to ask the court to consider my nephew's character, life circumstances, and potential for rehabilitation during sentencing. I have known Thomas his entire life, and have had the opportunity to watch him grow through both success and challenges. While understanding the seriousness of the situation before the court, I hope to provide some insight into the person I know beyond this offense. Thomas is a caring, respectful, and loving member of our family. Throughout his life, he has always shown kindness, empathy, remorse, relatability, generosity, and accountability. For example, Thomas has always helped me more times than I can count. When he was younger, before I had children of my own, I would pick him up and spend the entire day with him. He would ask me questions about life and tell me what kind of man he wanted to be. He would do things like open doors, carry heavy things, and as a teen, he always helped mow my grass and help make a little money. He had a job working on summer break, so he didn't have to ask for things. He was trying to become more independent. When his father was alive, the kids weren't really allowed to have friends or go places. Once his father passed away, their whole lives changed, and all the kids expressed their loss in different ways, and I think Thomas took it the hardest. Jessica did put them all in grief counseling. However, I don't think it helped Thomas much, as he was still hurting. We started going places as a family, all of us, all 11 of us, just to show up for the kids and to show them they're never alone. Now, speaking to him on the phone through this current tragedy, he has said multiple times how he wished he never stopped that night, saying he had never known, he never would have gone. Since this case began, I have seen genuine remorse and reflection from him. He has taken the responsibility for his actions and has worked to improve himself, completing online classes that are available to him, and is self-reflecting. I believe these efforts demonstrate his commitment to becoming a productive, law-abiding member of society again one day. I respectfully ask the court to consider not only the mistake that brought him before you, but the person he is and is progressing, or progress he has made, and the potential he has for a better future. Our family remains committed to supporting him and helping him continue to grow on a positive path. Thank you for your time and consideration and service to the community. Respectfully, Jennifer Stein.
Jessica, before you read your letter, multiple people have mentioned the loss of Thomas's father. How old was Thomas when that happened?
He was 13 years old.
I'm sorry, I didn't hear your answer.
He was 13 years old.
And was Thomas and his father close?
Yes.
You have a letter prepared?
Dear Honorable Judge Thompson, my name is Jessica Stein, and I'm the mother of Thomas Roy Stein. Writing this letter is one of the most difficult things I have ever done. And before speaking about my son, I want to first acknowledge the victims and their families. I want to express my deepest condolences to Kayla's family. As a mother, I can't begin to imagine their pain from this imaginable loss. My heart breaks for them. I also want to express my sincere apologies to Emma and Luann. No one should ever have to experience the fear and trauma they endured that night. My thoughts and prayers remain with them forever. They were changed by this tragedy. Thomas was only 16 years old at the time of this offense. He was attending high school. He started working a job. He was doing MMA, where he was learning discipline, respect, and perseverance. At home, he was a loving older brother who looked after his siblings and helped without being asked. He was always willing to lend a hand. He had a kind heart, a strong work ethic, and dreams of building a good future for himself. These qualities don't erase the choices he made, but they are part of who he is. It always has been. The loss of his father forever changed Thomas in ways that were difficult to understand at the time. I watched my son struggle slowly with grief and lose his direction. He became vulnerable and allowed himself to be influenced by people who did not have his best interests at heart. And I share this not to excuse his actions or lessen his responsibility, but because it is part of the story of how my son ended up before this court. From the very beginning, I have expected Thomas to accept responsibility from his actions. He understands that his decisions had devastating consequences, and nothing can undo the loss of Kayla's life, or the pain experienced by Emma and Luann and their families, and everyone else affected by this tragedy. He knows that remorse cannot change the past, but he also knows he must spend the rest of his life striving to become a better person because of it. Over more than 2 years, Thomas has been incarcerated. I've personally witnessed him grow and mature and reflect deeply on the tragedy that forever changed so many lives. I've seen genuine remorse and a willingness to accept responsibility and a commitment to becoming a better man through faith and self-reflection and growth. I believe he will continue using his time while incarcerated to learn and grow and become someone who honors the value of every human life the way he chooses to live. As his mother, I will continue to love him, support him, and encourage him to keep growing. I know he still has much work to do, but I also know the young man I have seen these past 2 years is not the same impulsive 16-year-old who made those terrible decisions. And I believe he has the ability to positively impact others, even while serving his sentence. And he continues to prove this through his actions that he has learned from this tragedy. I do not ask the court to overlook the seriousness of what happened or the immeasurable loss that Kayla's family suffered. I respectfully ask for mercy and for the court to consider Thomas's youth at the time of this event, the growth he has demonstrated during his incarceration, and the potential he has to continue changing for the better. Thank you for taking the time to read my letter and considering my thoughts during the sentencing. I appreciate the tremendous responsibility that rests with this court, and respectfully thank you.
Nothing.
You can sit down.
Judge, my client has a statement to prepare.
I'm sorry.
My client has a statement he'd like to read to the court.
Okay. Mr. Stein, just raise your right hand. You swear affirm testimony you give will be the truth, whole truth, nothing but the truth?
Yes, sir.
Okay. Would you like him to be on the witness stand?
Yeah, I'm gonna go.
Yes.
Thomas, if you could just say your name and spell your last name for the record.
Thomas Stein, Stein.
You have the statement that you've prepared.
Yes, sir. I just want to use this opportunity to address my victims, Dejae, Emma, and to Kayla's family, and to anybody else who was impacted by this crime, and to offer an apology. On March 17th of 2024, my actions would assist and forever change the lives of many people. That night I was implicated into the murder of Kayla Rincon Miller. And as I reflect on that night, I try to understand the damages and pains that were inflicted. But the truth is, I don't think I could approximate the damage that was done or understand the totality of what everybody went through. And I want you to know that I didn't know that robbery was going to occur, but it was my reaction in fleeing that ultimately played a major role in assisting the perpetrators. I know that it wasn't my intentions, but the truth is, it doesn't change the result. It doesn't change the fact that there was a life taken and innocent people were forever traumatized because of that. That day I made a terrible decision. The decision to get behind the wheel was a total act of selfishness, and it's something I regret and I'm ashamed of every day. I regret the fact that I will impact innocent people who never deserved to go through what they did. I regret the burden I placed on my family, who have always been there supporting me. I know me saying an apology will never fix or undo what happened. But regardless of that, I want to apologize for my actions that night and to say sorry for what you guys have been through and what you can continue to go through because of that. And Your Honor, before you sentence me today, I hope you can take into consideration the fact of my youth. I'm capable of change, and I know I can do it. And I know this crime says a lot about me, but it doesn't define me as a person entirely. And I'm remorseful for my actions, and I'm sorry. And I just ask you this one thing. If before I walk out the courtroom, if I could give my family a hug, if you'd allow that.
No, I can't grant that request in here.
Okay, that's fine.
You can say goodbye, but you can't have any physical contact.
Okay. All right. That's all.
Thomas, have you, while you've been incarcerated this last 844 days, have you completed any classes?
Yes, sir. During my time incarcerated, I've been spending countless hours on trying to change myself, rehabilitating. I've done countless courses, man, countless days and days, trying to find a purpose.
Nothing further, Judge. Thank you.
Okay. All right, you can sit down, sir.
Just argument, Judge.
Okay. Steve.
If I could first point out that the PDR that you referenced as well as the PSI are up for the court to consider. Within the pre-sentence investigation, the court might ask to note that the defendant does have adjudications of guilt as to felony offenses, and I wanted to talk a little bit about those. They're listed on page 4 as a burglary of a conveyance, and there's an error here in that it just says August 13th, the Lee County, count 1 burglary of a conveyance, and it says what the outcome was. And I think it's important that the court note that the defendant was on pending juvenile charges at the time of this offense, which is what led to that ultimate resolution, and I believe it happened here in front of your honor. Those cases ended up being direct filed as a result of this case coming to adult court. And in fact, there were 2 cases, not just one. They are both for burglary of a conveyance. And those were 23 CJ 4781 and 23 CJ 4782. Those became 24 CF 427 and 24 CF 428. I'm asking that the court take judicial notice of those court files because they are from the defendant's prior record. And in fact, he pled no contest to both counts of burglary of a conveyance. And I bring those up because I think what we've heard a lot from Mr. Stein's family is that this theme that he was hanging out with the wrong crowd, or he was being influenced by people who didn't have his best interests in mind, and it was causing him to make poor choices. And what we know from the case he was already facing in juvenile is that there were 2 individuals car hopping. One of them was the active party doing the car hopping, jiggling on door handles, going into the cars. Both individuals are wearing masks, while the other person is standing as the lookout, and it was captured on video. Later in that night, law enforcement chased an individual who appeared to be loitering and prowling. That person fled. In the course of fleeing, they lost their shoe, and they lost their cell phone. And ultimately, it was identified that Thomas Stein was both the person who fled from the police, as well as the person who was doing the active car hopping or trying to break into those cars, and that's ultimately the charges he faced. And those cases are important because at that time, Mr. Stein, wasn't the tag-along acting as the lookout. He was the person doing the burglary. And on top of that, when you consider those narratives and the probable cause that the court's taken judicial notice of and the defendant pled to, the defendant's mom was approached after law enforcement had found that phone and that shoe, and she explained, oh, my son was chasing the dog that had gotten out or something to that effect. And I understand that Mrs. Stein has faced something tragic here in what her son is dealing with here in court, but I think it demonstrates that Thomas Stein isn't the person who is being influenced by others, but Thomas Stein is the bad influence. Individuals in this case weren't all just hanging out and Thomas Stein happened to go along with them. We know from the facts that the court heard he was the driver. He had armed the parties. He was making the rap videos about doing crimes. He was doing all of those things. He's the one who identified the targets, the girls in this case who were walking down a dark road alone. He's the one that stalked back and forth. Your Honor, to suggest, and I understand the need for Thomas Stein's family to find answers as to how their loved one could be involved in this and wanting to minimize what his involvement was. But the fact is, he was the bad influence. He is the one who perpetrated this and caused it to be able to take place. He caused it to happen, and it was his actions that caused the death of Kayla Rincon Miller and caused the harm that has been suffered by Luann and Emma Wright. The jury did not find that he pulled that trigger, but as the court knows, everything that he did that night is treated the same with regard to his involvement. Talked about it during the arguments that you're in for a penny and in for a pound, and Mr. Stein was found guilty of the capital offense of felony murder. So I wanted to point that out about the PSI and make sure the court was aware of it. The factors that the court has to consider, and I should clarify, the state isn't going to ask that the court sentence the defendant to serve life in prison on count 1, first-degree felony murder. And under statute 921.1401, the factors the court has to consider in determining whether that is an appropriate sentence include both the factors relevant to the offense as well as the defendant's youth and the attendant circumstances. And I want to talk about those. They're labeled A through J. I'm not going to talk about each of those, but I think some of what we've heard today is important in your determination, and the state's going to ask that you weigh those and balance them. One of those is the nature and circumstances of the offense committed by the defendant. I'm not going to rehash what we heard at trial and what I just discussed, but this was not an accident. This wasn't the intention of going out to commit a robbery was clear from the evidence that was introduced at trial, and ultimately it's what the jurors found occurred because they did find the defendant guilty of felony murder. So the intent was to commit a robbery that ultimately resulted in the death of Kayla Rincon Miller. The effect the crime had on the victim's family and on the community. It goes without saying because the court's heard from the individuals the incredible impact that this has had. And I think the theme that the court heard essentially on repeat was the lasting impact. And I believe you heard that the impact didn't end that night for Kayla's family, and it certainly didn't end for Emma Wright and Luann and their families. This has been a continuing experience for them, and as Ms. DeJean said, it's something that she will experience for the rest of her life, the loss of her friend Kayla, as well as the trauma associated with being the victim of a robbery or an attempted robbery that night. You heard a lot about who Kayla Rincon Miller was, and that loss from this community is tremendous, and the court can and should consider that, and we're asking you to do so. The court should also consider the defendant's age, maturity, intellectual capacity, and the mental and emotional health at the time of the offense. The state would agree that the defendant in this case did suffer a loss and that his father passed away when he was at a very young age. However, what you also heard here in court from his family is that he had an entrepreneurial spirit and that he was goal-oriented and that he worked every day to do things to better himself, to help his family. He demonstrated a level of maturity that's commensurate with his age and perhaps even beyond. He had educational aspirations. He was in 10th grade and participating in the high school program at Mariner High School. He was doing the things that an individual who holds a high sense of maturity was doing. And so this was not a crime that was influenced necessarily by immaturity. And if there was a component of that, it played a very small role in what Thomas Stein did on March 17th of 2024. You can consider the defendant's background, including his or her family home and community environment. And what you saw in those photographs of the defendant is he essentially had an idyllic childhood. He grew up going on trips, surrounded by family. He has an extended family who's actively in his life. Siblings, aunts, uncles, grandparents, great-grandparents. By his own mother's account, she had everyone over on a regular basis. This isn't an individual who was left to his own devices and went down the wrong path. He had all of the support that so many defendants come before a court and say, I never had a good upbringing. Please have mercy on me because I didn't have a good upbringing. Thomas Stein had very evidently every benefit at his disposal. And the court can consider that as one of these factors under 921.1401. I'm going to skip here. One of the subsection G is the effect, if any, of the familial pressure or peer pressure on the defendant's actions. Again, Jessica Stein is talking about how her son was influenced. We learned through trial that the defendant was hanging out at his own home, playing with guns, making videos, smoking weed. His own statement during trial is that he was selling drugs and apparently guns on the internet illegally. This is not someone who was the subject of peer pressure, and I'd ask the court to consider that very, very strongly. And finally, letter J is the possibility of rehabilitating the defendant. And I would suggest to the court that the entirety of the reason that we have the sentencing scheme for juveniles who are direct filed involving a review of their sentence is to account for a defendant's ability to have rehabilitation while they're incarcerated. The point of that 15-year review, if the court sentences the defendant to greater than 15 years, is to check in and see, have they developed? Have they improved their lives? Do they have greater direction? Have they done the things that the defense is going to ask you to consider and give him an opportunity to do by giving him a lesser sentence? The state's asking the court to give the defendant the full sentence that accounts for the loss of Kayla Rincon Miller and the trauma suffered by Emma Wright and Luann DeJet, as well as their families. Give the defendant the full sentence that accounts for those losses. And at the 15-year review, the defendant will certainly get the opportunity to demonstrate that as a juvenile at 16, when he was involved in the commission of these offenses, that he has become a changed person because of it. The length of this sentence matters for today. And the state's asking that you do impose a life sentence after considering all of those factors. Again, the state would suggest that if the court imposes anything over 15 years, you have to have a written order and findings saying that he's entitled to that review. As to count 1, the first-degree felony murder, there is a 3-year minimum mandatory that's required because of the finding of actual possession of a firearm. So that is the minimum mandatory associated with count 1. And there's a 3-year minimum mandatory associated with each count because the jury found that the defendant did actually possess a firearm during the commission of the offense. We have just a moment, Your Honor.
Okay.
I indicated at the beginning when we were talking about the score sheet that I'd ask the court to consider and at least be aware of what the defendant was facing when he was merely facing a second-degree murder charge, and that was the 467 points, which equates to approximately just over 27 years as a lowest permissible prison sentence on a score sheet that includes a level 10 first-degree felony life offense with the 3 attempted robbery with a firearm charges. But we're not here for that lesser offense. We're here for the greater offense of felony murder, where murder was committed during the commission of an inherently dangerous activity of perpetrating a robbery. As to counts 2, 3, and 4, the state's asking that the court impose the maximum sentence of 15 years in the Department of Corrections, including that 3-year minimum mandatory. And if I can have just one moment to make sure I have discussed everything. The state has nothing further.
Okay. Mr. Wheeler?
Your Honor, prior to the trial starting, the defense and the state attempted to work this case out. The defense offer to resolve the case was 25 years for state prison with a 25-year minimum mandatory. Something that was along the lines of Mr. Horn's sentence. The court sentenced, I think it was just last month, Mr. Horn received a 25-year sentence without a minimum mandatory. Judge, obviously there's no downward departure allowable under the law for murder. But I think it's telling that the statute that the state has referenced alludes to the fact that special consideration should be given to juvenile offenders. And this is because of their lack of development of their adolescent brain, which isn't done developing until the age of 26. I'm sure the court is fully aware of all the arguments made for youthful offenders. But in addition to that mitigator, I think the trial made it very clear that Mr. Stein, contrary to what the state is asserting, was acting in the domination of another. According to his testimony, Judge, he was tasked to pull over to check out these girls, and I hate to remind the court again, but he was the only one not wearing a mask at this point. He's the only one not trying to hide his identity. So in reference to the sentence that Mr. Stein should receive, there is an argument for parity amongst the defendants and proportionality given his role during the course of the robbery. The jury has found him guilty of being present, having possessed the firearm, and I hate to correct the state, but I think it's actually a 10-year minimum mandatory for each count that applies to his cases. So what the court has before it is an opportunity to sentence Mr. Stein from 25 years up to life on count 1, which is the felony murder charge. We would ask for a concurrent sentence on counts 2, 3, and 4. We're asking the court to impose a sentence that's proportional to that of Mr. Horn. As a direct filed child found guilty of a principal and felony murder. This young man stands before the court. He's still young, he's malleable, he's not without potential. We ask the court recognize that and not discard it. Accordingly, Judge, we're asking the court to impose a sentence of 25 years in Florida State Prison with a 10-year minimum mandatory with probation to follow, with a 15-year, obviously, review. Thank you, Your Honor.
All right, thank you. All right. Anything else from the state?
Nothing, Your Honor. I was just looking at 775.087 to review that minimum mandatory, and
Okay.
I haven't finished reviewing that. But I would
I'll take a
prefer
short
to-
recess and come back, let you look at that, and I'll come back.
Yes, sir.
Please be seated. So first, let me start I'm sorry. All right, for the record, the state's present, defense counsel, defendant are present. I have reviewed the statute that was last mentioned regarding the minimum mandatory sentence. It does appear from my reading of the statute, 775.087, subsection 1, 2A, maybe. Let me go back to it. It does indicate a 10-year minimum mandatory sentence for the attempted robbery with a firearm on each of it. So I believe defense counsel is correct on that.
The state would agree. I just got the wrong number caught in my head, so I appreciate
Okay.
it.
And I'll just put that on. Let's see. Yes, it's Florida statute 775.087, subsection 2, subsection A, subsection 1. Indicates that. All right. Was there anything else from either the state or the defense regarding sentencing?
Nothing from the state.
All right. And Mr. Stein, was there anything else you wanted to address with the court prior to the court pronouncing sentence? Okay. So I have presided over the trial. I've listened to all of the testimony, the arguments. I've listened to the victim impact statements as well as the statements from Mr. Stein's family and the letters presented by his mother and Mr. Stein's own statements regarding sentencing. I have reviewed, at the state's request, the Florida Statute 921.1401, based on the state's request for a life sentence, the factors that the court must consider. And in that statute, 921.1401, subsection 2, A through J, are the following circumstances the court must consider. It says, in determining whether life imprisonment or a term of years equal to life imprisonment is an appropriate sentence, the court should consider factors relevant to the offense and the defendant's youth and attendant circumstances, including but not limited to, and I'll go through each of these factors. A, the nature and circumstances of the offense committed by the defendant. The jury found Mr. Stein guilty of the offenses charged in counts 1 through 4, and that he did actually possess a firearm. The nature of the offense was violent in nature, terrorizing to the victims based on their testimony, and certainly tragic in all manner. The victims had done nothing to encourage violence against them. They did not participate in any way in having an altercation with the defendant or the co-defendant, that they were innocent young women walking home from a movie, which used to be parents were comfortable letting their children out at night, out of the house, and be out in the streets. And most parents in this community for many years felt that their children were safe. This is the kind of crime that makes parents afraid to let their children out at night, and certainly had an impact on the victims and an impact on the community as well, and that addresses the subsection B, the effect of the crime on the victim's family and on the community. Subsection C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. The defendant was 16 years old, had, based on the evidence and testimony, an apparent knowledge and comfort with firearms, that he knew what they were, he knew what they did, and was not something that was foreign to him in possessing or using a firearm. His age, even though 16, his maturity, based on evidence, was that he drove a car, was provided a vehicle, he was capable of doing many things that 16-year-olds can do, and maybe even a little bit more, because he had developed a sense of independence after his father had passed. Leading into subsection D, the defendant's background, including his or her family home and community environment. Certainly from the testimony, the defendant had a supportive family. He had many responsible adults and caring brothers and other family members that were there for him. And he had those resources available to him up to and including through today. While his family faced tragedy, and Mr. Stein himself, I'm sure, suffered that tragedy of his father's loss, families face tragedies, and yet are able to come together and support each other and help each other get through that and still remain productive members of society. So he had a significant family support in his background, and the court notes that. Subsection E, the effect, if any, of immaturity, impetuosity, or failure to appreciate risks and consequences on the defendant's participation in the offense. reviewing the testimony in trial and statements made today as well, the defendant really was more mature in some ways because of the loss of his father and his obligation that he seemed to express to step up and help provide in the family and take care of siblings and do things that many people at 16 don't have to do. And so he developed that ability and showed that. And so his level of maturity actually was probably more than that of a 16-year-old. As far as his failure to appreciate risks and consequences on his defendant's participation in the offense, it is shown that he did have prior interaction with law enforcement as a juvenile with the burglary of a conveyance. So he understood that there were rules, laws, and then if you broke them, there were consequences. So he was not unaware of that. And so the court finds that he did have sufficient maturity and ability to appreciate the risks and consequences of his participation in this offense. F is the extent of the defendant's participation in this offense. The defendant had opportunities to not have this offense happen. It was noted in the trial by the court that the evidence of the video showing the vehicle that he drove passed by the victims more than once. He didn't have to come back. Now, I understand the defense's argument that he was influenced by those in the vehicle, but he drove that vehicle. He brought that evil to the victims, and he had the choice to do that on more than one occasion or to avoid that. The effect, so subsection G, the effect of, if any, of familial pressure or peer pressure on the defendant's actions. The court notes there may have been some peer pressure on the defendant. However, again, he had opportunities to get away from that pressure to avoid this incident and prevent it from happening. H, the nature and extent of the defendant's prior criminal history, very limited. We have the one offense that was noted as juvenile for burglary of a conveyance. J, the effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. He was 16 years old at the date of this offense. He had a prior experience with law enforcement. He understood that there were laws and there were consequences of violating laws. He understood and appreciated the nature and the use of firearms. There was a video and evidence of him holding a firearm, pointing it into a camera, making rap songs about it. He indicated that he was comfortable holding and using a firearm. In terms of the judgment, or his youth, the effect of his youth on his judgment, it was noted in the pre-sentence investigation report that he said if he had known this was going to happen, he wouldn't have done it. Something to that effect. Or he wouldn't have participated. The evidence in this case shows there were signs all along that something bad was going to happen. It was indicated in the testimony and trial that the defendant and Mr. Horn had intended to go and commit car burglaries. Yet, it's also shown that there's a video of them taking firearms with them and testimony that Mr. Stein provided Mr. Horn with a firearm. Certainly, when you're 16 years old and you're getting in a car with someone else and you give them a firearm with the intent to go commit crimes, there's an indication there that you understand that bad things can happen. So again, it wasn't something that was a surprise or came out of nowhere. There were different events and circumstances throughout that day and that night that tragedy was probably going to happen. Subsection, that was I. Subsection J, the possibility of rehabilitating the defendant. There is that possibility based on testimony from his family. He's got a supportive family. He has indicated that he is remorseful and that he wants to do better in terms of his life, and that he wants to rehabilitate himself and become a productive member of society. That is possible. Whether or not that happens will be up to Mr. Stein. So it is the considered judgment and sentence of this court that Mr. Stein shall be sentenced to a term of life imprisonment in the Florida Department of Corrections with a 15-year review. So we will have that opportunity to make that assertion in terms of rehabilitation after 15 years. And like I said, your possibility of being rehabilitated will be up to you. And that is for count 1, which was the first-degree murder with actual possession of a firearm as a principal. That comes with a minimum mandatory sentence of 25 years. Is that right? No, 10? 10 years. There'll be certain statutorily mandated fines, fees, and costs that accompany that. And I'll go into those in a minute. As to count 2, attempted robbery, actual possession of firearm. And let me just go back. I'm sorry. On count 1, the jury had found you guilty, and I previously adjudicated you guilty on that count. On count 2, attempted robbery with actual possession of a firearm, which is a second-degree felony. Jury having found you guilty and me previously adjudicating you guilty on that count. Your sentence in that count will be 15 years in the Florida Department of Corrections with a 10-year minimum mandatory sentence as part of that 15 years. That sentence will be consecutive to the sentence in count 1. Count 3, attempted robbery, actual possession of a firearm, a second-degree felony. The jury having found you guilty of that count and the court previously adjudicating you guilty, you will be sentenced to 15 years in the Florida Department of Corrections with a 10-year minimum mandatory as part of that sentence. That count will be consecutive to count 2. And in count 4, attempted robbery, actual possession of a firearm, a second-degree felony. The jury finding you guilty of that count and the court previously adjudicating you guilty on that count, your sentence will be 15 years in the Florida Department of Corrections with a 10-year minimum mandatory. That sentence will be consecutive to count 3. As for the monetary obligations, there'll be $413 in court costs. I believe it was previously stipulated to cost of prosecution was $2,565.05. As for, is there any application fees? I will order restitution on each count, reserve in any amount. There'll be no contact with the victims' families or the victims. Were there any other terms or conditions?
Nothing from the state now.
All right. I'll have the state prepare an order based on my findings as to Florida Statute 921.1401. I believe that's all. Anything else from the defense?
Judge, because of the court's sentence on counts 2, 3, and 4 as a consecutive sentence, it goes in the face of what the court has ordered in count 1 in terms of the 15-year review. Even if it comes back and the court finds that he has really rehabilitated himself, concurrent sentence.
Okay, and I've thought about it. I've considered it, and the sentence the court's imposed is what I believe is appropriate under these circumstances. So I will leave it the way I've ordered it. I will. Let's see. I will tell you, Mr. Stein, you have 30 days from today to file an appeal. If you can't afford an attorney for an appeal, one will be appointed for you, and you will get fingerprinted and remanded. I will give you a few moments before you're taken out. You can say a few words to your family before you go. You just can't have any physical contact in the courtroom. Anything else from the state? All right. Anything else from the defense?
Judge, if we fill out an indigency application?
I'm sorry?
If we have Mr. Stein fill out an indigency application before he leaves?
No, not today. I think if you want to, I mean, if you just file it through the portal, I think, is the way typically it's done. But I think for today's purposes, he just needs to get fingerprinted, have a few words with his family, and then get remanded. Is that, I mean, you're able to do it back at the jail?
Because my concern is he's going to be taking the South Florida reception before I get a chance to go over there and have him fill out the application.
Any objection from the state, or?
I don't have an objection. I think it usually they just file a motion saying he's indigent for cost of made out. And
That's how I usually get it.
They don't actually fill out the form to do that.
Yeah.
I said it with Brandon, he wanted to do an indigent application, so.
I can find that he has been incarcerated the whole time. I don't find any change in his income or circumstances in that regard, so I have no problem or finding that the defendant is indigent for those purposes at this time. That's sufficient for the record, and you can just put that in your proposed order. All right. Thank you. And I'll just wait while he gets fingerprinted, and then. We'll be in recess.
Leave it. You almost fell. You almost fell. Yeah. Oh, come on.
I'm gonna borrow this box since you can roll it, please. The one that's right here. These ones are better. Okay.